Maybe not.
I was like, what if the book has these?
We think so. Let's see if there's some people.
So we should meet next week. Is he?
What is that? It's like a little long. It's like, no, I'm sure that's not the case.
Right now.
I don't know, that's exactly what she's doing. She's intelligent. She's better cooking for the art. I just do it after you. Okay.
I don't even know about
That's not quite a battle though.
it's kind of this lady.
I'm here. He looked at me, I know, but that's major. I can't call it. So, running for office, it's not gonna happen. Someone's gonna ask me a question of debate when you're real, and then my. Who's the presidential, when the primary takes tonight? Who does the primary?
I had to take all my clothes off.
I feel like you should be doing off on all the time.
The tobacco smell was so.
Well,
And it's just a baby steak.
afraid to say we're testing. Wow. Okay. This is one powerful mind.
I was like,
I just heard myself breathe. So you did too. Not that I coughed. Okay. So unless I'm mistaken, this mic isn't on. Am I mistaken? Okay. I will do my best not to breathe, cough, sneeze, make a sound other than a word. Oh wait, there was one right there. Okay, if this gets too annoying, we're gonna have to do something. Well, hide this somewhere. I know, it's painful, isn't it?
Can you turn down the game on it?
Turn down the game.
Thank you.
I don't know what that means.
Yeah, we don't have to.
Okay, I'm going to turn down the game. The gain is like the sensitivity or something? Oh,
I don't
then
know
that's
where it is
definitely
on
been
this side.
turned down.
I should have it somewhere. Which one? Oh, yeah, no, usually this goes by, so it's all good. Try this, and then if that's
That
too
would be
loud,
so cool.
if this is too loud, go to the negative.
Testing, anyone there?
Is that too far?
I don't know. Is it picking me up?
No, no.
No.
I have
That's two favors. A little more gain?
It only has 3 levels of game. I mean, it has to be right up, and it makes you up at this level without feeding back. That was feedback.
Okay.
So you're gonna
It's
get-
big symbol. Wait, no, let's see.
So that's the loud one.
Is that good? Is that good? Maybe that's good. Let's try it. Okay, if we get too many broken eardrums, just tell me. We'll do something about it. I didn't even breathe just then. Who was breathing then? I think there was someone else's breathing.
Is it rubbing against your lapel?
No.
I want it down the mic receiver inside your jacket. Maybe try your tie. Try the tie.
Better. Oh, look at that. Breathe and chew.
Oh, it's a tie mic.
It's high as the wake up. Okay. All right. Well, welcome back, everybody. Sorry not to see you last week, but I'm not sorry that I didn't personally have to take midterms like you did. So, no envy there. But I hope they went well for everyone. Got some grades coming. Hopefully they'll be great. So, haven't gotten any other grades yet? You've gotten every other grade. Our survey went well? Sorry to hear that.
It's okay.
But how important is a bar exam, right?
I'm not taking it.
But it's a midterm. If it didn't go well, maybe there's time to make it that grade, get that grade high. Yeah. Always. So, all right. Today is Mardi Gras, Fat Tuesday, Shrove Tuesday. What's another name for today? Day before Ash Wednesday. Plenty of names for that. Ash Wednesday is when we kick off the Lenten season. So we kick off some fasting. Who's ready for some fasting? I see no excitement for fasting.
I eat in the morning, I just wait for the rest of the day.
Wow. Okay, so that's hardcore.
But then I always forget and end up eating meat anyway. Somehow I always forget.
It's a nice thing to be able to forget.
Yeah, because it wasn't done intentional.
Yeah, there's no intent.
Right.
Like that. Yeah. So I guess the Mardi Gras, the Shrove Tuesday, the Fat Tuesday came from the custom, I don't know when, of trying to use up the sugar or the fats in the house before the fasting started. This is what I'm hearing on the radio. If it's on the radio, it's gotta be true, right? So I guess it's what comes from. Yes, those are like a Polish donut, is it? Oh, I'd love to have one of those.
They're on sale at Publix right now.
Oh, nice. But I gotta get them before midnight, right?
Yes.
And then I gotta eat them all before midnight. Ah, the chores I have to do. I'll do it. I'll take one for the team.
You're good.
Yeah, thank you. I had some Krispy Kreme this morning, hot off the donut maker. You ever get the donuts while they're still hot? You know, before they've cooled off? Oh, it's so nice. Yeah. They were fried in the deep fat fryer. Oh, so good. Yeah. I'm getting myself hungry here. Yeah. And once the fasting starts, I'll be even hungrier. Oh, Lord willing, I'll lose some weight. That would be nice. Well, we'll see. We'll see. But anyway, my prayer as always goes out to all of you. My prayer is that your midterms come back with some great grades that you're happy with. My prayer is that you have a successful Lent. My prayer is that if you happen to go to an Ash Wednesday service, that they give you a nice clean cross. You ever get one of those crazy smudges, you know, or you inadvertently touch it and turn it into a crazy smudge? Been there, done that, right? Every year, happens every year. So there's an elderly gentleman who's got an office condo just down from my office condo, and I see him in the hallway every Ash Wednesday, and he does the same thing. And I know he's not being a wise guy. I know he's being genuine. I know he just doesn't remember that he does this every year when he points to my forehead and says, "You've got something on there."
They do it here all the time. That happens to me.
Like, it happens,
What
right?
are you talking about? Oh, shit.
We've all done it. We've all done it. So my prayer goes out that maybe we'll have a nice cross on an ash there and a great Lent, a successful fast, and get closer to God through a great Lent. So that's my prayer. In the name of the Father, and the Son, and the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women. Blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, we fly unto you, O Virgin of Virgins, our Mother. To you do we come, before you we stand, sinful and sorrowful. O Mother of the Word incarnate, despise not our petitions, but in your mercy, hear and answer them. Amen. Father, Son, and Holy Spirit, amen. Got a great class and a great chapter for you. It answers some of the questions that were left unanswered by our prefatory chapter that we covered last time. That chapter had to do with counties and municipalities. One of the things we noted about counties in that chapter is that it had the power of lawmaking. But of course, the power of lawmaking is primarily vested in the legislative branch of the state legislature. So here in our chapter on the legislature, we're going to take a look at lawmaking and its limits under Florida's Constitution. And of course, this chapter is on the legislative branch. Once we're done with it, our next chapter will be on the executive branch of Florida. Once we're done with it, the next chapter will be on the judicial branch of Florida. So in case it's somehow a surprise to you, we have 3 branches of government under Florida's Constitution. I hope that wasn't surprising. But let me ask you this, is that required? Must the state have 3 branches of government? Well, we know from the federal Constitution that there must be a republic. There must be a Republican form of government. And by saying a Republican form of government, the federal Constitution is not talking about the two major parties in our nation, the Democrats and the Republicans. It's talking about a representative democracy called a republic. So we're guaranteed a Republican form of government in each state. But from there, we're not in particular guaranteed three branches: legislative, executive, and judicial. Likewise, you'll note, and you probably already know, that Florida's legislature is a bicameral legislature. And I'm not talking about camels, the things we use to travel the desert that have humps on their backs. No, I'm talking about bicameral. I'm talking about two separate parts. That is a House and a Senate. So we have a bicameral legislature here in Florida. And again, to ask the question, is it required that we have a bicameral legislature? And the answer is no. Indeed, as the book noted, there was a proposal on the ballot for Floridians to vote on once, where we would have had a unicameral state legislature. That was voted down, and our legislature is bicameral here in the state of Florida, just as it is, I believe, in every state, certainly as it is in the federal Constitution. As you know, there's a federal Senate, there's a federal House of Representatives. Likewise, here in Florida, we have a state Senate, we have a state House of Representatives. But it wasn't required that it be bicameral. Now, one question to ask, and of course, many of us are a product of an education that was part information and part indoctrination. One of the things we were indoctrinated to was that the separate branches of government are separate but equal. Have we heard this term before? Anyone encountered in their studies of civics, their studies of the federal government, the term is separate but equal? And is that true? Is our federal system of government three separate but equal branches? Let's explore that for a little bit. But first, of course, we've got to identify the three different branches of federal government. For those of you who are not familiar with it, and probably you're already familiar with it, we've got the first branch of the federal government. That's the investigative branch, right? The second branch of federal government would be the lawmaking branch, right? And the third branch of the federal government would be the injunctive branch. Right? Because we all are familiar with the House and the Senate, and they spend their day just investigating everything, right? Investigate this, investigate that. You know, who won the last election? Let's investigate it. You know, why did this happen? Let's investigate it. So we've got the federal investigative branch. Now, they don't bother making any laws, right? So then we've got the president and his men go ahead and signing executive order after executive order. So that makes them the lawmaking branch. And of course, we've got the federal courts who note that lawmaking was supposed to be done by the legislature. So they're busy entering nationwide injunctions against the president and his men. So that's our three branches of federal government, right? No one's laughing. I worked so hard on that joke, I got it written down here. You know, what I think it is you're waiting, you're holding your laughter for the joke of mine that's funny, and there isn't one. So just go ahead and laugh at what you get. It's the best I can do. Yes?
So then would you be of the opinion that Ginsburg and Sotomayor should recuse themselves like Trump is asking?
Well, you know, it's interesting because we begin the chapter on the judicial branch about the accountability of justices of the High Court. We compare and contrast the accountability of the Supreme Court of the United States versus the Supreme Court of Florida. What ethics rules apply to them, whether or not you can move to recuse, what standards apply based on recusal. We're going to talk about that then. So it's an excellent point, and it's certainly part of the curriculum. I'm going to get into it 2 chapters from now. But I'm looking forward to hearing your opinion and everyone's opinion about whether there should be an ability or a greater ability to get a recusal from either a state high court justice or a Supreme Court of the United States justice, and what accountability there should be for our justices. We'll see the different standards, and we'll evaluate which one is best, or maybe both are lacking when it comes to the standard that applies to the Florida Supreme Court versus the standard that applies to the U.S. Supreme Court. So yeah, you bring that up, and you bring it up for good reason, and I'm going to bring it up again. So I'll be back to you on that.
Sounds good.
Yeah, but of course, I'm joking about the federal. In the federal, we've got the legislature, not the investigative branch. We've got the executive not necessarily the lawmaking branch. And we've got the judicial, which is not necessarily the nationwide executive branch, but gosh, sometimes it feels that way, doesn't it? So these three branches of government, I guess, for some of us, we've been indoctrinated to believe that they are separate but equal. But if you don't mind me turning to education instead of indoctrination, is that true? Are they separate but equal under our federal system? What do you think? Let's think about it. Let's work it through. Now, if you're in the legislative branch, right, you've been elected, and you might have folks to help you. You might have members of you wouldn't call it a cabinet, they'd be part of your legislative office, right? Office staff and things. Who gets to choose those? Well, you do, right, as an elected official. If you happen to be elected to the US Senate, the US House, that's your choice. Compare that to the highest ranking federal executive. That would be the president. Her or his cabinet is nominated by the president, but with the advice and consent, right, of the legislative branch. So can we call those two branches separate but equal? Is it equal to say, I have power over you and you don't have power over me when it comes to your cabinet or your assistants? What about removal? Of course, if a member of the federal legislative branch, such as a senator, House of Representatives, is unethical or improper, certainly that House or that Senate can bring up that member on charges, and if convicted, can expel that member. But can the president expel any of those members? Can the judiciary expel any of those members? No. Compare that to the highest ranking federal executive, that would be the president. What if the House or the Senate doesn't like the president, wishes someone else had won the election for president? Can't the House and the Senate working together impeach and remove the president? Well, they can. So are they therefore separate but equal? If this branch can remove even the highest ranking member of that branch, but that branch can't remove even the lowest ranking member of the other branch, does that make them equals? Think about it. If you had a job and your manager can fire you, but you can't fire your manager, should you go around saying, me and my manager, we're separate, but we're equals? Are you really equal? What about the judiciary? Are they separate but equal? What if the Congress passes a law? Can the judiciary say, well, yeah, that's a law, but if I had been elected to Congress, I would not have voted yes on that law. Therefore, we will not be enforcing that law. Can the judiciary say that? Well, God forbid. I guess in theory they could, but they certainly should not. And if a member of the judiciary rules that way, if there's a higher ranking judiciary, such as if it were the trial court, you could appeal, right? And it would be overturned on appeal, because that's not the definition of unconstitutional, is it? Is a law unconstitutional if the particular judge you're in front of simply just doesn't like that law and she or he feels that had she or he been elected and was called upon to vote, would have voted against that law? Does that make the law unconstitutional? No, it does not. So can't the legislature, by passing laws that are constitutional, exercise control over the judiciary? Are those two branches, federal legislature and federal judiciary, separate but equal if one controls how the other goes about its business? So I know we're all a product of an education that has taught us that these three federal branches are separate but equal. But if you don't mind doing it, every now and then you can stop and say to yourself, hey, just because I was commanded to believe this, is it true? You're allowed to do that. And in my humble opinion, law school is a great place to do something like that. So are the three federal branches separate but equal? We could go on with other examples. But I hope you'll agree at this point that at least the argument can be made. You may agree, you may disagree, but the argument can be made that they are separate, but perhaps not equal. Indeed, if we look back at history, the argument can be made, and you may agree, you may not you may disagree, but the argument can be made that at least some of our founding fathers did not intend the three branches to be equal. Certainly separate, but not equal. Some proof of that is in the Federalist Papers. Some proof of that is in the text of the federal Constitution. And I mean no disrespect to law schools. Law schools, you've been there when you study federal constitutional law. You don't really open the text of the federal Constitution, right? But there are some who prefer to look at the text of the Constitution and see what it means. And when you see examples such as one branch having control over another, that seems to imply that the branch with control was more than just an equal of the branch that it's controlling, right? So some could argue that even in the federal system, it's the legislative branch that ranks highest in the hierarchy. You may or may not agree, and that's okay. I'm here to educate, not to indoctrinate. You can reach your own conclusions. I'll give you the facts and the data. You come up with the right interpretation. But if it is true that the legislative branch is supreme over the other two, would that be a good idea? Again, that's a matter of opinion, but let's think that through so that you can reach your own opinion on that. When we look at the various branches, which is directly accountable to the people? Well, on our federal system, we see that our members of the Senate and the House of Representatives are the result of an election. You and I voted, yes or no, more than yes or no. You and I voted what individual will hold that particular seat. And based on a 10-year census that we update every 10 years, we do our best to apportion evenly or appropriately through the population how many folks will get to vote on a particular House of Representatives seat. Likewise, because of comity, C-O-M-I-T-Y, to the rights of states, we give each state 2 senators, regardless of the population. So no matter where you happen to be, you get to vote on the appropriate number of senators and members of the House of Representatives, and you pick their names. Can the same be said of the judiciary? Did you get to pick the names of the judges that are there? No, you did not. The legislature, which in theory might be the supreme of the 3 branches of federal government, as your representatives, with the nomination of the executive branch, gave advice and consent and installed those federal judges, correct? You didn't get to pick a name. There weren't competing candidates for you to vote on. Now the president, make no mistake, regardless of who she or he is, you didn't vote directly by name for that person either. You did vote on a ballot that bore the name, but the results in that ballot was electors that went to, what's the name? How do we pick a president? Is it a direct vote? What's that?
Electoral college.
Thank you, Electoral College. So you voted on a name, but the result of that name was not to install that individual into the office of president. It was instead to instruct the electors to vote for that person in the Electoral College. So it was the Electoral College that installed the president. Likewise, the cabinet, those were unelected officials. They were nominated by the president, confirmed with the advice and consent of the legislative branch. So if one branch had to be supreme, shouldn't it be the one that's directly elected by you and I? Shouldn't that be the one with the most power? If indeed the power would be out of balance. That's one hypothesis I put out there for you. Perhaps you have a different hypothesis, but I'm here to educate, not to indoctrinate. Your hypothesis is no less wrong or right than mine. I'm just giving you the data so you can make a decision. So with that said, how does it work under a state constitution? And the answer is found in the text of that state constitution. Because, as we can see from the case law in our book, the federal government does not interfere and does allow state constitutions to spell out the various forms of government, so long as we have that Republican form of government that the federal constitution guarantees. And what I have for you there, two different cases. You can find them in the beginning of your chapter, after the lower of the article. And you've got two cases that spell out something we call a police power. The police power is the basis for a state's ability to engage in lawmaking. You can see, as you compare and contrast the two cases, that they come to the same conclusion as to the source of the police power and the extent of the police power. I'm referring, of course, to Jacobson versus Massachusetts. That was a 1905 decision from the Supreme Court of the United States, the excerpt of which I followed with State versus Saez. That was the 1986 decision of the Supreme Court of Florida. So comparing and contrasting Jacobson with Saez, first we note that Jacobson comes from SCOTUS, Supreme Court of the United States, whereas Saez comes from the Florida Supreme Court. So we have different case there from different courts. Looking first at Jacobson and the rulings of SCOTUS, we can see here, quote, the authority of a state to enact a statute is to be referred to what is commonly called the police power. Compare that to Saez, quote, the Florida legislature enacts statutes under the state's police power. So as we compare and contrast the two high courts, we see agreement there, do we not? Turning back again to Jacobson, what is commonly called the police power is, quote, the power which the state did not surrender when becoming a member of the Union under the Constitution, quote. That was SCOTUS's ruling in Jacobson. Compare that to the Florida Supreme Court in Saez, which says, quote, the state's police power derives from the state's sovereign right to enact laws for the protection of its citizens, quote. So again, we see agreement between the two high courts. They both view the police power as an inherent power, inherent in the state. Saez describes it as inherent due to a state's sovereignty. So Saez says, and it is correct in saying, that the states are individual sovereigns who have united as a group called the United States, but in so doing had sovereign power prior to the Union. That's roughly what is said by Jacobson, where SCOTUS says that the police power was a power the state did not surrender when becoming a member of the Union under the Constitution. So regardless of which way you choose to phrase it, what we have is a recognition by both high courts that there was an inherent power in the states. And it is that inherent power that allows states to have legislatures and to create state laws. So let's apply that knowledge. Do we need the federal Constitution to say that a state can enact state laws? What's the answer? I heard someone say no. Whoever that was right, so don't be shy. No, we don't. It's sometimes said that the state constitution is not a source of power, but instead is a limitation upon legislative power. It's sometimes said that that's true, and that's unlike the federal constitution, where the federal constitution serves as a source of Congress's legislative power. So when we look and compare and contrast the federal legislature with the state legislature, what we find is that the federal legislature, on the one hand, requires constitutional power in order to enact a law. On the other hand, the state has an inherent power vested in its legislature, and as we'll see in a minute, sometimes delegated to counties and municipalities, but an inherent power vested in its legislature to enact laws subject only to the limitations of a constitution, such as the state constitution, the federal constitution, and the federal laws enacted pursuant to the federal constitution. So what we're saying here is that the power of the state legislature is inherent and subject to limitations, whereas the power of the federal legislature is absent unless found in the federal constitution. See the difference there? What then do we call this inherent power? We call it the police power. And don't be confused, just as you weren't confused by the phrase bicameral wasn't referring to camels. Police power isn't referring just to law enforcement officers. When we say police power, we're talking about the inherent power of the state legislature to pass laws. When is a law valid under the state's police power? There is a limitation, and it's differently phrased in the two high court opinions. Let's turn first to the Supreme Court of the United States in Jacobson. There, quote, in the police power of the state must be held to embrace at least such reasonable regulations established directly by legislative enactment as will protect the public health and the public safety, end quote. Compare and contrast that quote from SCOTUS and Jacobson to this quote from the Supreme Court of Florida in Saez. The police power, quote, however, is not boundless and is confined to those acts which may be reasonably construed as expedient for protection of the public health, safety, welfare, or morals, quote. Do we have there a distinction without a difference? You note from SCOTUS's language, we're talking about public health, public safety. You note from Supreme Court of Florida language that we're talking about public health, safety, welfare, or morals. Do we have a distinction without a difference? And I dare say that as case law continues to evolve, we may learn the answer to that as to whether we have a distinction without a difference or whether there is a difference. If there is a difference, it might lie in the choice of the word morals. Clearly, the police power can enact laws for public safety. Clearly, it can enact laws for public health and welfare. Can it enact laws for public morals? And if so, whose morals? Your morals? My morals? What source of morals? A civic source? A religious source? Time will tell and perhaps answer such questions. So then, turning to our notes and questions to consider, let's look at question number one. One, in the context of state constitutional law, what is the definition of a state's police power? When may a state exercise it? Who can help me here? What is the definition of a state's police power? It's times like these, I think I should take attendance. Shall I get an attendance sheet? Let me do that. And in so doing, not only will I know who's here or who's not, but I can randomly call on victims. I mean volunteers. Yes. Oh, yes, I've got a volunteer who saved everyone else who didn't want to be called on. Thank you, sir. Who can we thank? What's your name, sir?
Yes, I love this part. It's going to be recorded too.
Well, thank you. Thank you for doing it. Wait, signing if you're here. Yes.
The camera.
Oh,
ALAELDEANE is capitalized.
ALADE.
You can do it. I just want to word it.
Oh, I'm already doing it. All right. A-L-A-T-E.
No. He has it.
Oh, yeah, dude, I've gone wrong already.
Yeah,
Okay,
I'm very disappointed.
I'm sorry.
It's okay.
I'm gonna try to do better. A-L-A-E.
Don't fail. L, D,
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 E,
A,
A,
N.
N.
You want my two middle names?
Alleluia. Was that even close?
No.
Sorry. Teach me, I want to learn, I want to get it right.
Okay, cool. Sorry, I don't say it. Okay, so State Howard, please Howard.
Oh, wait, no, I want to get your name right first.
Oh,
Yeah.
okay, my ego just went up. Aladdin, the EL is silent.
Aladdin.
Yeah, my parents are good.
Oh, Aladdin.
Yeah,
Aladdin.
yeah.
Aladdin.
Yeah.
Got it. Mr. Aladdin, you have the answer. So what is the state police power?
It's inherent to each state, just don't contradict the federal government.
Yeah, perfect. Anyone disagree? Mr. Aladdin nailed it. Sir, second part of the question was, when may a state exercise the police power?
You used to be my favorite professor. Anytime.
Okay, but if there were a limit upon it, how would you describe it?
I'm sorry, all I have is don't contradict the federal government.
You're right. And if we did have to spell out a further limit, we might say it's for the health, safety, and welfare. Now, what strength is this limit? Not much. Because we're gonna apply a rational relationship test, right? If the legislation has a rational relationship to the health, safety, and welfare, then it's not going to violate any of those constitutions that you just mentioned, Mr. Allen. Yeah. So you're absolutely right.
Yeah.
If I had to give it a little more detail, I would give it that. Just health, safety, welfare. Yes. Okay, hopefully I have an answer.
It sounds like the test is rational basis.
Absolutely. Thank you for picking that up. That's what I'm trying to lay down. You picked up what I laid down. Thank you.
Yes, but Roe versus Wade established strict scrutiny when
Oh,
it came to fundamental rights. So-
Yeah, that's when we get into the details of potentially violating one of those constitutions that Mr. Allen mentions.
Yeah.
So when it comes to a test, do you want us to apply rational basis?
When appropriate. I love that you're diving in deep. I'm talking about the basis being the police power. And what is the basic limitation upon the police power? The basic limitation upon the police power is that it must be for the health, safety, and welfare.
Yeah, but when,
On top of that, very rudimentary, very low level of scrutiny, that rational relationship between the law and health, safety, and welfare. There are times when state legislation will run afoul of the state constitution, perhaps, the federal constitution, perhaps. Within the federal constitution is a federal supremacy clause, right? Remember that on the big board? You studied that. Remember we looked at the text of the federal supremacy clause found in the federal constitution. It said that this constitution and all laws made in pursuance thereof were supreme to all state laws, even the state constitution. For that reason, sometimes when there's a conflict between the federal constitution and the state constitution, federal constitution wins. When there's a conflict between the state constitution and not the federal constitution, but a lower level of federal law, such as U.S. Code, Act of Congress, generally speaking, federal wins because of the supremacy clause. When we took it down a notch, it was a lower source of federal law. It was just a code of federal regulations. It was just a low budget, unelected federal agency passed a regulation, put it in the CFR. It contradicted the highest level of state law, state constitution. Which one won? Federal wins. When we knocked it down even a lower notch, there was no statute, there was no regulation. There was just a ruling of the United States Supreme Court. It contradicted the state constitution. Which one prevailed? Federal wins. So it took it down a notch. The U.S. Supreme Court hadn't ruled on it yet. It was just a appellate court, federal appellate court. It contradicted the state constitution. What happened? Federal wins, and we took it down a notch. It hadn't even made it to the federal appellate level. It was just a federal trial court, and it contradicted this highest expression of state law, the state constitution. What happened? Federal wins. So yes, when we go beyond just the mere definition of the state police power, we can find that a state's law can be unconstitutional. But before we get into those details, I just want to talk about what is the basic source? How is it that a state can pass a law in the first place? And that basic source is the police power. And even that basic source, it does have its limit. It's not a very broad or powerful limit. It's just that it has to be for the health, safety, and welfare. So, and courts will defer as to whether it is for the health, safety, and welfare. They will defer by applying that rational basis test. So that's what I'm trying to say there. I'm not trying to contradict everything you learned in Federal Common Law 1, but I am trying to explain how is it that a state can go about making laws. That's what I was trying to do there. Continuing now with our notes and questions to consider, look at Note 2. Note 2 asks, what are the limits of a sovereign state's police power? We discussed part of that a moment ago. Remember, even a state's constitution can itself be unconstitutional. But let's look just at the police power for now. If the police power says I can do whatever the health, safety, and welfare of the citizens require, how broadly can I construe that? And I reminded you of the Lochner era in our federal history. There was a time where the Supreme Court in the Lochner era, the Supreme Court of the United States, decided to put itself in the shoes of the federal legislature when it came to economic legislation. The Lochner era was a time where the Supreme Court said, if you didn't make wise economic choices, then your unwise economic choice would be unconstitutional under the federal constitution. And as we know, the Lochner era is no longer. It is now a despised era. It is now not true that the US Supreme Court will step in and choose economic winners and economic losers. During that era of the Lochner era, the Supreme Court's excuse for supplanting the federal legislative role of choosing economic winners and losers with a judicial role was something akin to a police power. And as we just discussed, when we talk about a police power, that is inherent with the states, but it is either written in or non-existent in the federal constitution. Remember, a state constitution, unlike the federal constitution, is a limitation upon legislative power, not a grant of legislative power. The flip side of that same sentence is that the federal constitution has to grant legislative power, whereas for a state, we need not find a grant within the state constitution because we have an inherent police power. So one of the many criticisms of the Lochner era is that the Supreme Court of the United States during the Lochner era forgot that very basic principle of constitutional law. And that's what I try to point out in Note 2. So with that basics explained, the basis of the police power, what other limitations are there upon an ability to make state law? For example, is it just the state legislature that can make state law? Anyone wish to hazard a guess?
No.
No, you're correct in saying no. Where else can we find state laws being made?
The counties.
What about counties? In our last chapter, we looked at counties. We took all the land in the state of Florida and we divided it into 67 counties. There's not a single acre, not a single part of an acre that fails to reside in one county and exactly one county. Counties have the ability to make laws. And as we studied in that chapter, those laws can take away your money. Those laws can take away your freedom. Not only your freedom to build or not build, your freedom to take down a tree or not take down a tree, your freedom to drive or not drive on a particular road or place, but your freedom to be free. Violating county law can find yourself in county lockup. You can literally lose your freedom. You can become a prisoner for having violated a county law. How could that be? How do we have such power in counties? And the reason is Article 8 of Florida's Constitution. We looked at this language previously, and what we found is that regardless of whether it was a charter county or a non-charter county, the plain language of Article 8 of Florida's Constitution contemplates a county having a governing body, contemplates it enacting laws that we refer to as ordinances, contemplating legislating on topics that might also be addressed by Florida's legislature or a municipality. So just because the legislature has a law in the books on that topic, does that mean the county cannot pass laws on that topic? Not necessarily. It may still have the power. The concept of preemption describes when the county lacks the power to pass along the same topic. If there's not preemption, or if there's incomplete preemption, then the county can pass a law on this very same topic that the Florida legislature did. Likewise, if there's not preemption, or there's not complete preemption, the county can pass a law on the same topic that the city or other municipality passed a law on. Florida's Constitution, Article 8, contemplates that counties will record its laws. So you can find them on the books. And nowadays you can find them on the internet. Contemplates that counties will name punishments applicable to those who violate them. And that's how your client can find her or his freedom denied with handcuffs and imprisonment based on violating something that wasn't illegal under the federal law, wasn't illegal under the Florida legislature, but was illegal under a county ordinance. That can happen. What about municipalities? And here we talk about geographical entities that are no larger than a county, usually smaller than a county. If we're not in Jacksonville, certainly smaller than a county. The city of Jacksonville and Duval County, what's the name of that county up there in Jacksonville? Duval, I was right, I doubted myself. The city of Jacksonville and the county it resides in, Duval County, its borders are coterminous. Every inch of that county is also within city limits. But that's unusual for Florida. That's the only city that is as large as a county. Every other city, town, township, hamlet, or other municipality is geographically smaller than a county. Can they make laws? Can they take away you or your client's money or freedom?
Yes.
The answer is yes. Article 7, Section 2 of Florida's Constitution empowers, takes that inherent police power, extends it not only to counties, but also extends it to municipalities. Municipalities shall have governmental, corporate, proprietary powers to enable them to conduct municipal government, perform municipal functions, and render municipal services, and may exercise any power for a municipal purpose, except as otherwise provided by law. McGinley, you were wise to highlight that language. There's a restriction there, right? Sort of. Under Florida's Municipal Home Rule Powers Act, we provide a definition for that highlighted phrase there, municipal purposes. And under Florida's Municipal Home Rule Powers Act, we define municipal purpose to mean any activity or power that may be exercised by the state or its political subdivisions. Well, what power doesn't fall under that? Exactly. The best I could say is, if the municipality did it on purpose, then it had a municipal purpose. It's the best I can say. In theory, there was a limit to the police power, right? had to be for the health, safety, welfare, perhaps for the health, safety, welfare, and morals. But we reviewed on the rational relationship test, if it ever got to court, whether it was true that it was for health, safety, and welfare. Likewise, when it comes to municipal purpose, the definition is so broad, so permissive, that it's very hard to even contemplate something that wouldn't be for municipal purpose. You might dare to say if the municipality passed that law on purpose, then it had a municipal purpose. Not a lot of restraint there. But there are constraints, there are restraints, there are limitations upon lawmaking, whether that lawmaking is done by the state legislature, or the county, or the municipality. So let's take a look at lawmaking and its limits. When we look at lawmaking and its limits, one of the first things we turn to is that law, here's a more detailed definition for you of municipal purpose. If you see a big constraint or restraint in there, please let me know. Case law doesn't find much at all. But if it's exercising its authority for a valid municipal purpose, there's no constitutional or statutory limit on the exercise of that authority. But isn't it always true to say that you can't pass an unconstitutional law? Okay, so if it was an unconstitutional law, then it wasn't for a municipal purpose. Gosh, that was a lot of help. It was already unconstitutional, right? Did it need to violate something else other than the Constitution in order to be null and void? So there's a technical definition for you. But let's turn now to some lawmaking and its limits. One of the things that we know is that there has to be a proper subject matter. So what are the proper subject matters? Let's take a look. Municipalities can enact legislation concerning any subject matter on which the Florida legislature can act. But there are these exceptions. First, when it comes to annexation, merger, or exercise of extraterritorial power. When we talk about annexation or merger, what we're talking about is taking your city and combining it with another city. That would be merger in order to create one unit, one new city. Annexation would be taking some land that is coterminous with the city but isn't currently within city limits and adding it to city limits. Remember Allen's Creek? That would be an example of an annexation, right? So these laws are the first exception. What is extraterritorial power? That's quite simple. If you're the Orange County Board of County Commissioners, you have the power to pass Orange County ordinances. You lack the power to enact Seminole County ordinances, or Duval County ordinances, or Orange County ordinances that apply to folks outside of Orange County. Make sense? Yes?
Is there a way to get around these exceptions, like if you get permission from the legislator or?
Yes, and now you're alluding to what we might call special laws or laws of local application, which I put at the very end of this chapter just before ending with quasi-legislative. So we are going to cover those. If that is something that gets a bit tricky, but we're going to cover it. It's a good point, and it's a potential. But the general rule is, if you're the Orange County Board of County Commissioners, your power is over Orange County. It's not over the entire state. It's not over the entire nation. You might declare yourself a sanctuary city where particular federal laws don't apply or something like that. But generally speaking, you lack the power to actually enforce a law like that, generally speaking. The second exception is for any subject expressly preempted by the Florida Constitution or general law. As I alluded to earlier, you can have laws on the same subject passed by both Florida's legislature and counties or municipalities if there isn't preemption. Preemption is when a law either states or can't exist without being the final say on that topic. So there can be express preemption where the law says municipalities and counties may not pass ordinances that conflict with that state statute. On the other hand, courts can find implied preemption, where the court analyzes the Florida legislature's statute and says, well, this doesn't work. This wasn't intended to be nullified by lower sovereigns. This doesn't work unless we imply that the state has preempted the field. So preemption can be expressed or it can be implied. The third exception, any subject expressly prohibited by the Florida Constitution. So if the Florida Constitution says that there's a way to do a thing, then doing that thing in any other way is unconstitutional under Florida's Constitution. The fourth exception is any subject preempted to a county pursuant to the county charter. This is where things get interesting. As we mentioned earlier, geographically speaking, the municipality, the city, or the town, is never geographically bigger than the county that it's in. A city has to reside, a municipality has to reside within one county and one county alone. So the maximum the city can be is just as big as the county, as we see in Jacksonville and Duval County. With that one exception, every other city is geographically smaller than the county it's in. Every other municipality is smaller geographically than the county in which it resides. So intuitively, you might look at the geography and say, oh, that means the county always wins. The county always preempts the municipality. And that's not true. For a non-charter county, the municipality preempts the county's law. So if you've got a county that hasn't passed a charter, we call that type of county a non-charter county, as you recall. And when we discuss such things, one of the questions that one of you was wise enough to ask was, well, why would or wouldn't a county pass a charter? One of the considerations is that preemption. Without a charter, the municipality's laws preempt county laws. That may seem counterintuitive because geographically the county is bigger and geographically the city or other municipality is smaller. But it's a function of the charter. Any county can pass a charter, then send that charter up to Tallahassee, where Florida's legislature can pass a special law. And by doing all those things, that non-charter county becomes a charter county. When the charter county does so, it may include, but doesn't have to, a supremacy clause within its charter. Remember our federal constitution? Remember the federal supremacy clause? Remember when I introduced charters? Remember when I said that charters aren't truly a constitution, but that in certain ways it's a fair analogy? This is one of those ways in which it's a fair analogy, because just like our federal constitution contains a supremacy clause, didn't have to, but it does. Likewise, a county's charter can contain a supremacy clause. It doesn't have to, but it can. That supremacy clause can say either all or some or certain stated ordinances of the county preempt those of the municipalities within the county's geographic boundaries. So think of it as a function of charter, not as a function of geographic size, and you'll get it right. Lawmaking and its limits. Let's start the big board, shall we? Let's keep a list of these arrows in your quiver, if you will. I call them arrows in your quiver because I imagine you as the litigator. You might imagine yourself the same way. Imagine you're representing a client. Imagine that client has violated a law. And here, unless stated otherwise, we're talking about a statewide law, we're talking about a statute, we're talking about an act of Florida's legislature, but we could also be talking about an ordinance passed by either a county or municipality. What if you represent a client and they just violated that law. But they've hired you to escape the punishment that goes along with that violation. One of the things you might be able to do with these arrows in your quiver is prove that that particular statute or ordinance is unconstitutional on its face. As we make this list on the big board, these are the arrows in your quiver that you can use to strike through the heart of duly enacted laws, because those laws exceeded the limits of lawmaking under Florida's Constitution. So here we have a power that I'm vesting in you. These are our elected representatives. These are duly enacted laws, but you can strike them down. You can make them null and void. You can make them unconstitutional on their face if you can prove that they violated one or more of these limits upon lawmaking that we're going to cover. So maybe that gives you some interest in the things that we're going to put here on the big board. First thing we talked about was proper subject matter. And let's summarize that again. Let's look at that in a slightly different way. Let me put on one slide everything we've talked about when it comes to proper subject matter. It's a bulky slide, but it's a summary. Nothing new here. First, Florida's legislature, what's proper for it? As we know from prior chapters, and I pulled them in here, Florida's legislature can pass a law on any subject matter that is not preempted by federal law, right? And not forbidden by the US or the Florida Constitution. Remember, we kept score. As I kept lowering the rank of that federal law, federal kept winning, right? Here's another way to summarize that on the left side of this slide. That's what's proper for Florida's legislature. On the right side of the slide, what's the proper subject matter for lawmaking by a Florida municipality, county, city, town, hamlet? Any subject matter on which the Florida legislature may act. So its universe of possible topics is just as broad as the Florida legislature's universe of possible topics, with the potential exception being that it has to act for a municipal purpose. And you remember how broad a restriction that was, right? It's almost as if it's not there. So if you don't mind me doing it, let me just erase that from the slide. Technically it's there, but come on, wasn't much of a restriction. Here's three more weighty restrictions. The first was annexation, merger, or exercise of extraterritorial power. That's not a proper subject matter for a municipality or a county. Second was any subject expressly preempted by Florida's constitutional general law. Again, that's not a proper subject matter for a municipality or a county. And third was any subject preempted to a county pursuant to the county's charter. So the county has the power, with the aid of its population and with a special law from Florida's legislature, to create a charter that has a supremacy clause that gives it the ability to preempt the municipalities within its jurisdictional boundaries. Make sense? That in one slide summarizes, well, this summarizes it better because I put that technical language back in. But even with that technical language out, this slide summarizes what we've talked about so far when it comes to proper subject matter. So we have proper subject matter on the big board. That's one of the arrows in your quiver. Let's talk about another arrow in your quiver that we studied in our chapter. An ordinance versus a resolution. God bless you. An ordinance versus a resolution. Illustrated there was the case of White versus Town of Inglis. I love this case. You know why I love it? I love it because people are always telling the lawyer jokes, aren't they? About how bad we are, or I don't know, what crooks we are, you know, why didn't the shark bite the lawyer? You know, professional courtesy, you know, all these terrible jokes. But if there is any profession, if there is that's more maligned than the lawyer, it's what? The used car salesman, right? And again, just like maligning our profession isn't fair, it's not fair to be maligning these used car salesmen. But it happens all the time, right? You sound like a used car salesman with that argument, right? Doesn't that happen all the time? I can say this because I own 2 used cars. And you know, even if you bought your car new, the next day it was a used car. Did you notice that? So we all own a used car. We do. So I don't know why used car salesmen and women are blind. Just like I don't know why lawyers are blind, but they are. But White versus Town of English, it involved the dirty, rotten, forgive me, sir, as I erase your name. The dirty, rotten used car sales. Right? We had the highway here, right? Yeah, or maybe it's 2 lanes, maybe it's 4 lanes, maybe it's 6 lanes. It's certainly commercial. But then coming off the highway was a tiny little residential street, right? Here, little boys and girls are playing, throwing ball. Maybe they have a little hockey net here in the middle. When I grew up in Howard Beach, Queens, we used to put the hockey nets right there in the middle of the street. And then when a car came down the street, we had a little timeout so we could move the nets. The car could go by, and then we put the nets back. Anybody else grew up in an urban environment like Howard Beach, Queens, where you play hockey in the street? No? Nothing but country girls and boys out here? Well, ask someone who grew up in an urban environment, and they'll tell you
Well,
that.
we play street hockey,
Yeah, street hockey.
yeah.
Yeah. Over here, we've got the used car salesman. And what does the used car salesman have on the used car salesman's lot? Used cars. Ooh, yucky. I own 2 of them. I love them. It's a much better deal than a new car. It really is. But ooh, yucky. Used cars. And what's the used car salesman doing before he sells these jalopies, these lemons? He's letting people take test drives. We want them test driving over here on the super highway. We don't want them test driving over here, the residential street, right? Where we got the nice sign here, you know, welcome to Winter Park. Please drive with extraordinary extraordinary care. No one knows that sign in Winter Park? Ah, you're not locals. Anyway, so what do? Being enacted that there should be a fence blocking this driveway so that the used car salesman has to use only his other driveway. So all the jalopies and lemons and used cars will be on this busy super highway, not over here. So the county passes that resolution, be resolved. Next day, county workers put up the fence. Next day, the used car salesman ripped the fence down, started driving jalopies on that street again. You represent the used car salesman. What's your defense? Which arrow in your quiver? How do you strike through the heart of that legislation, render it null and void as facially unconstitutional? What was the flaw? Resolution. Yes, be it resolved. What do you call a law that begins with the phrase, be it resolved? A resolution. Remember we studied the definition of resolution and ordinance? Here's why you want to know that definition. When a resolution is passed, but an ordinance was required, then the resolution is facially unconstitutional. What is the punishment for having violated that resolution? None! Used car salesmen get off scot-free. Jalopies keep driving through town. That was the whole of White versus Town of English. And that is the takeaway. What is a resolution? It's a legislative enactment of a temporary nature or of an administrative task. Be it resolved that we will find a new city manager. That sends into action the administrative task of finding a new city manager. But if you want to do something of a permanent nature, or something that's not an administrative task, it's got to be passed as an ordinance, not as a resolution. In White versus Town of English, they passed a resolution. But a fence isn't administrative and a fence isn't temporary. That fence was permanent. That resolution was facially unconstitutional. Got it? That's the takeaway. That's the example that White versus Town of English gives us. So that's an Aaron equivalent. 6 procedural requirements. Can I pass a law any old way? No, I can't. There are at a minimum 6 procedural requirements. 1, you've got to print and publish a notice of intent to pass that law 10 days prior to taking it up for a vote. 9 days, 8 days, 7 days? No, 10 days. Where do you publish it? Well, no one's got the internet in their pocket. You gotta put it in a newspaper, right? Anybody here subscribe to a newspaper? I know you read them online, but I mean like you wake up in the morning and it's, there's plastic bags sitting on your lawn. Anybody? Anyone? Okay, there's someone. Respect that. I don't mean a lot of people though. But yet the law still reflects this idea that we're all getting the newspaper thrown on our front lawn in the morning every morning. So number 2 is that it's published in a newspaper of general circulation, general to that population. Rule number 3, there's a required format and there's some required statements that have to appear in the notice. Those are stated in the law. You have to copy and paste them. Number 4, there is an exception if there's an emergency. So I can skip 1, or I can skip 1 and 2, or I can skip 1, 2, and 3 if I prove up number 4. If I prove up an emergency. How do I prove up an emergency? That lawmaking body has to take a vote, and a supermajority of that lawmaking body, 4/5, have to agree there's an emergency. But there's a caveat on that too. Number 5, there's an exception to the emergency exception. No matter how urgent you think it is never an emergency if you're affecting the zoning map. No such thing as a zoning map emergency. I don't care if you got 4/5, I don't care if you got 5/5. Maybe you're strange with the math and you somehow got 6/5. I don't care how many fifths you got. There is no such thing as a zoning emergency. And number 6, this arrow in your quiver, it has a statute of limitations. You've got a 5-year limitation upon an action for failure to adhere to these particular requirements. So even if these requirements have been violated, you've got a 5-year statute of limitations. Maybe your client didn't violate a particular ordinance or statute until year 6 or 7 or 8, I'm sorry, the statute of limitations has run out on the exceptions to see on this board. So that's the arrow in your quiver you might call procedural requirements. Let's talk about the single subject rule. Get ready for this one. Not everyone can handle this one. Law's gotta have a single subject. I went through that quickly. Let me slow down. Law's gotta have a single subject. One more time, slower. Law's gotta have a single subject. How'd I do? Can anyone do it slower? I like to teach you when the easier ones go along. But when it comes to amending Florida's Constitution, you don't have a single subject rule. So when there's an amendment on the ballot to change the Constitution, you can do some mob rolling, you can do some bundling. And you may have seen that, especially in 2018. There were all these unrelated things, and you had to vote yes or no on all of them. And maybe you liked numbers 1 and 3, but you didn't like number 2. Or maybe you liked number 2, but not 1 and 3, but you couldn't divide it up. You had to vote yes or no. That's the opposite of the single subject rule. When it comes to the Florida legislature and its municipalities and its counties, each law has to have a single subject. Your hands up, yes.
Are these things like paperclip bills?
I'm not all that familiar with the phrase paperclip bill, but maybe that's just another way of saying log rolling. Are you talking about when you add something onto the bill in order to get a vote for it?
Yes.
Okay, so you call it a paperclip bill, I've seen it called log rolling, but I guess the concept is the same. In the book, a beautiful example I thought was Obamacare. Let's see what we got there. That was, I thought, just the epitome of a violation of the single subject rule. Didn't I quote Obamacare in here? Yeah, here it is. This is under notes and questions to consider, note 1 under the single subject rule. The ACA, the Affordable Care Act, is 900 pages long. Its regulations include requirements ranging from break time and secluded place of work for nursing mothers to displays of nutritional content in chain restaurants. The act raises billions of dollars in taxes and fees, including exactions imposed on high-income taxpayers and upon tanning booths. It spends government money on, among other things, the study of how to spend less government money. Wow, we spend some government money on figuring out how to spend less government money. It includes a number of provisions that provide benefits to the state of a particular legislator. Yeah, so, we need Senator so-and-so's vote. Maybe Senator so-and-so like a bridge to nowhere, or a library in the middle of somewhere, or some pork barrel money for this or that. This is the opposite of the single subject rule. And at least when it came to Obamacare, if we believe the ruling of the U.S. Supreme Court, it was all on purpose. It says here, such provisions validate the Senate Majority Leader's statement, quote, I don't know if there was a senator that didn't have something in this bill that was important to them. And if they don't have something important to them, well, that doesn't speak very well of them, quoting Senator Reid. So I guess you're just not a very good politician when it came to passing Obamacare if you couldn't get some pork barrel for your contingency in there, huh? So that's the difference there when it comes to lawmaking and its limits under the federal versus the state. Under the federal, can I buy myself some votes? We don't call it corruption on the federal level. We call it a lack of a single subject rule, right? Can I buy myself some votes if Senator so-and-so, doesn't like this legislation? I'll throw some millions Senator so-and-so's way that Senator so-and-so can spend on a pet project, or be able to tell Senator so-and-so's population, hey, I brought home the bacon, It's not corruption on the federal level. It's just a lack of the single subject rule, right? But here we have an example of greater constitutional rights for Floridians. We have a right to be free of our legislature spending our taxpayer dollars in not what's called a bribe or corruption, but in what's called, you called it what, paperclip? Paperclip bill, rider, law ruling is what I've seen there. It all has to do with judicial integrity. Under Florida's constitution, we have greater protection from, law ruling, paperclip bills, buying votes, whatever polite term you want to describe this level of corruption with. But here, you've got to have a single subject. Now, there are some exceptions to Florida's single subject rule, and the first is the title. We began this chapter talking about how a bill becomes a law. I'm just a bill. Yeah, I'm only a bill. Some of you remember Schoolhouse Rock, others don't. But there's a nice description there about how a bill becomes a law. And one of the things you'll note is that you've got to have a reading of the title. So the title can be quite broad and can be quite lengthy. And the title can mention more than one topic. So long as the title doesn't violate the title requirements, and that's a separate arrow in your quiver that we'll go over in just a minute. So long as the title requirements haven't been violated, you might take two seemingly disparate topics and tie them together properly within a properly written title. And then, as long as they're both in the title, you don't have a violation of the single subject rule. So you could call this, I guess, the Affordable Care Act and Nutritional Content at Chain Restaurant Regulation Act and Break Time and Secluded Place at Work for Nursing Mothers Act and Billions of Dollars in Taxes and Fees Increased Act and Tanning Booth Regulation Act and Study of How to Spend Less Government Money Act.
All those
And
things
then-
sound like they're covered under the bubble of healthcare now.
You think those all fall under healthcare?
Yeah.
Okay, so you don't see this as a violation of the single subject?
Nope.
Okay. I disagree, but we can agree to disagree.
Just Florida not do the same type of stuff though, like in the 2017 House Bill 716 or 7069, they had over 100 like little things in the title for education, many of which were diametrically opposed. It was ridiculous. They buried so much stuff in there. Is that not the log rolling?
It may be. There's two exceptions. We covered title. The second one is a corollary. And forgive my difficulty in pronouncing that word, but you see it written on the board there, corollary. Hope I'm pronouncing it right. But something that is a corollary to the topic of that law is allowed. And to give an example, I would turn to Florida Statutes, Chapter 440. That's our workers' compensation law. It spells out the compensation given to workers when they get hurt at work, which naturally you would expect a workers' compensation law to spell out the compensation given to workers. But it also spells out another judiciary and creates within the Division of Administrative Hearings an Office of the Judges of Compensation Claims. And then it spells out the particular qualifications to serve as a judge of compensation claims, or JCC. Unlike most judges, they have to have a stated number of years' experience in workers' compensation law. And it also spells out where the funding will come from for the offices of the judges of compensation claims, and spells out what the title will be for the executive that's running those particular offices, is the deputy. So what happened there? We've got a step removed from its primary purpose, which was to provide compensation to workers in the workers' compensation law. But these other steps removed are corollaries to providing that compensation. Because although it wasn't a judicial, this microphone's driving me crazy today, folks, I apologize for it. Although it wasn't a judicial law spelling out the acts of the judiciary, it was a corollary of how to get the compensation in the hands of the workers. So that wasn't a violation. So the example you gave, perhaps there were corollaries in the law. That would not be a violation of the single subject rule. Perhaps seemingly unrelated topics were tied together in the title. That would not be a violation of the single subject rule. Or perhaps it was just a violation. Legislatures can, and in history have, passed laws that are unconstitutional. When that happens, it's incumbent upon a litigant to argue, bear the burden of proof, and win the litigation proving the unconstitutionality of that act. So it could be that there's an unconstitutional law on the books right now. That has happened in history.
But wouldn't it be easy for someone to just create an overly broad subject like education or healthcare or whatever it is, to put a lot of unrelated things that all fall under the branch of education? They're all correlated to education somehow, but are really completely different.
Well, yeah, especially when you combine the two exceptions, the title and the corollaries. You might take two seemingly disparate things, or 3 or 4, make sure they're all in the title, and then draw upon the corollaries of each. And that way you might be able to garner votes and circumvent the anti-law ruling intent of the single subject rule. I agree. But at least we have the intent. At least we have the single subject rule. Unlike the federal government, where you've got quotes like from this Senate Majority Leader Reid just bragging about, well, of course there's pork barrel in our law. And if you didn't get any pork for your jurisdiction, you're just not a very good senator. We have the opposite of that here in Florida. We at least have a law that tries to curtail that type of corruption, if you will. So, is it a perfect solution? Probably not. But it does address the problem, or it tries to. So that's the single subject rule. And that's another arrow in your quiver. We've got more arrows for the quiver. Let's take a 5-minute break before we get to them. Sorry that it's not a 10-minute break, but let's break for 5, shall we? I'll see what I can do about this microphone.
I was only what I meant.
I see the font, but, you know, it's like, I know it's so we can actually what is about if we have a lot of poultry. The poults are getting bigger and bigger. This one's just bigger. That's actually a lot worse. I don't know, it's like, no, I like it. But I mean, do you want to? I'm interested in practice. I kind of got a sense. You know, maybe this bill that I'm looking at, it has like mandatory recess time, which is a good thing. It makes your teacher's salary, blended with money for charter schools, away from public schools. Oh, they're gonna vote away kids' recess, but now the charter schools get money. But it was supposed to be people. They are on the terrible. They're just, yeah, they don't understand. I mean, let's run like an office too. Fix them, but I can't policy for shit. So I kind of want to. No, I was like heating the wall. Heating a head up. I see that. What about you, Josh? He's for sure not part. I'm pretty.
No,
Probably. Trust. Okay. All right, these are which departments to go in.
that's what I do.
There's a firm I did that, where, from my work. I don't think Ricky's interested.
She may be on. That's what. Because we were talking about it. Did you do?
I'm sorry?
Are you on her? That's a legit.
I don't know. This was for me, for the breeze. In terms of. It's easy, like, the sentences are quite simple. I mean, I get the idea about doing like Uber and stuff like that. Oh, no, they are. Do you get the arguments? They are like she's touching it so specific. It's hard arguments. Well, I see the thing. Well, the arguments of this. They have a handout.
Hopefully this mic is gonna be less intrusive to our ears. Sorry about all the humming and popping and breathing and I don't know what else you got. Feedback. Gain, is that the word I learned?
Gain is like controls. I don't know how to describe it.
Well, whatever it was, there was too much of it, I guess. All right.
The sensitivity, controls the sensitivity.
Yeah. Next is amending existing laws. It's the next arrow in our quiver. Generally speaking, can you amend a law? Say someone passed a law last week, last month, last decade, last century, 150 years ago. Are you allowed to amend that now? Yes. Yes, of course you can amend a law. But there are some requirements that have to be met under Florida's Constitution if you're going to amend an existing law. And those requirements are summarized on this slide, except for the in re D. Woody exception for repeals by implication. And I've got that down to about a page, right? Maybe a page and a quarter in re D. Woody. So that's worth reading. But other than the example you see there in re D. Woody, you can never amend the law solely by reference to its title. You can't say, Florida's Workers' Compensation Act is hereby amended as follows, or Florida's murder statute is hereby amended as follows. Never just by reference to the title. Instead, what you've got to do is print out the law again, and then you underline. Literally put that underscore. You underline the text that you're adding to the law. The text that you're deleting from the law, you literally cross it out. So as this bill is circulating in the legislature, and folks are hopefully reading it before they vote on it, hopefully, right? When it comes to something like the Affordable Care Act that was 900 pages long, you wonder. But on a shorter law, you hope they read every word of it, right? And here you have the existing law typed out verbatim. The words you're adding to it are added there, and they're indicated by an underline. The words you're taking out of it are also indicated by the strike through, by the cross out. You literally type it up that way. You've seen bills, right? You've seen that they look like that. They don't look like that for convenience or because it looks dandy. It's constitutional, that requirement. It is unconstitutional to amend an existing law in any other way. Striking the sunset clause, and I put that in quotes because it's a slang I use. I don't know if I'm using it exactly right, but striking the sunset clause is insufficient to revive the statute. And what do I mean by that? Well, you have laws that have expiration dates. Are you allowed to enact something into law and state in that law that it expires on a date certain?
Yes.
Of course, yes, you can. What if the law's been on the books and the expiration date is coming, but you liked that law? You don't want that law to expire on the expiration date. Can I simply state that the expiration date is hereby repealed? No, you've got to do what you did with any other amendment to a law. You've got to spell out the law in its full. You've got to underline what you're adding. You've got to put a line through what you're subtracting. Here, the only thing you're subtracting is that expiration clause, but nevertheless, you're circulating among those who are voting on it the entire text of the law with the hope that they're doing the job you elected them to do and that they're reading the full law before they vote on the law. That's true even for laws with expiration dates or sunset clauses, if I'm using that phrase right. And a resolution is insufficient in order to repeal an ordinance. Be it resolved that ordinance number 2001 is hereby repealed. That won't work. In order to amend or repeal an ordinance, you have to enact an ordinance, not a resolution. So that's the arrow of your quiver, requirements of amending existing laws. We talked about laws having titles. We talked about that when it came to how bills became laws. We talked about that when it came to the single subject rule. There are requirements for titles, and here are the top 5 check mark boxes in front of each one for you. First, the title is not part of the statute or the ordinance, but the title does reflect legislative intent. There are those times when courts inquire as to what the intent of the legislature was. The title is part of the answer as to what the legislative intent was. But the title itself is not a law, and the title itself is not part of the law. Indeed, when you see the Florida statutes codified, or you see them in Florida statutes annotated, you'll see them without the title. You'll see a short title, a couple words, but the full title, you'll need to go back to the bill to see that. Second, what can be in the title? And the double negative here is on purpose. It comes from the case law. The contents must be, quote, not inconsistent. Don't shoot the messenger with the double negative. So the contents must be not inconsistent with the general subject of the title. And I think perhaps the case law's use of the double negative was to emphasize the fact that it doesn't have to be consistent. It's not a requirement that the contents must be consistent with the general subject of the title. It's only required that they be not inconsistent, which I think when you analyze the case law, you'll agree, as I hypothesize, that it's a lower standard to say that it's not inconsistent rather than to say that it must be consistent. The case law doesn't require it to be consistent. The case law requires that it be not inconsistent. Double negative. Third, as I noted earlier, you might avoid a single subject rule violation by use of a well-drafted title. Fourth, a title is sufficient. And again, I put this in quotes because it's the legal standard from the case law. A title is sufficient if the topics are, quote, fairly related, quote, to it. Fairly related. So when is it fair to call it a corollary? When it's fairly related. That's the legal standard we use. So it may be absent from the title. You may argue that it's a corollary. When it comes to whether the title was sufficient, it's sufficient. The question is whether that topic was fairly related to something we find in the title. For this reason, a title may not be 4 words long, or 8 words long, or 12 words long, or 20 words long. Titles might be 30, 50, 70, 80 words long, or more, for good reason. What is the purpose of the title? Well, you remember, it's the part that's read out loud. Yes, you've got your hand up.
I have a little confusion in terms of determining what is related or I feel like that's very ambiguous in terms of like the subject in mind to say, okay, this might be these are the derivative of this subject.
Yeah. Well, the question is whether or not it's a corollary. So that's one standard. And then fairly related gives us another standard. But I agree with you that despite the existence of those two standards, there's still quite a bit of wiggle room. That's going to bring us to one of our rules of construction, one of our canons of construction of Florida's Constitution. And that is, if we can interpret the legislature's act as constitutional, then that's the preferred interpretation. So if we've got two interpretations, both of which are fair and supported by the facts and the law, then we're going to favor the one that gives us a constitutional law. That doesn't mean we can pass unconstitutional laws, but it does mean when we get into fights as to whether or not it's a corollary, whether or not it's fairly related, if it could fairly go either way, then we're going to interpret it in the constitutional way. So I hope that helps to answer your unanswerable question, because your question has to be answered on a case-by-case basis, and the answer is going to be different based on what law we're looking at. But we do know we have those three legal standards to apply: corollary, fairly related, and the canon of construction that prefers a constitutional interpretation over an unconstitutional one if both are proper interpretations. I guess ultimately that left your question unanswered, but it gave you some tools that you can apply. So the purpose is to give adequate notice of what the law entails. That's the purpose of the title. So we add that to our arrows in the quiver. The next arrow in the quiver has to do with zoning laws. Remember how there could never be an emergency when it came to a zoning law? Remember that? There's another requirement for a zoning law. Now I could use a good microphone. Let me try that again. Okay, this will do it. Hold on. That's someone knocking at your door. Yeah, zoning laws, unlike other laws, require individualized notice to the landowner. Ordinance that pertain to a specific activity rather than the use of property, those are regulations. Those are not zoning ordinances. And those are subject to less stringent notice requirements before passage into law. But when it comes to the zoning map, when it comes to how your land is zoned, that's a zoning law. And rather than just 10 days notice running in the newspaper, I got to print that notice with you, the landowner's name on it, and send it to your address. Is it fair to burden the government with this? Oh yeah, Because what is it that makes you a landowner? Do you remember from property law? Can you just shake hands and now ownership of land is transferred? No, what'd you have to do? You needed what? A deed? That's right. And other than a lady bird deed, what do you got to do with that deed to make that deed effective? Record it. Where? With the county where the land is. So why not require the county where the land is to look at the pieces of paper you filed with it, make some use of that data, and send individualized notice to these landowners before you affect their rights to use their land by affecting the zoning. That's exactly what Florida's Constitution requires. See how that works? Works beautifully. As time goes on, should other laws have the same requirements? Something to think about. But putting that futuristic question aside, in the here and now, when it comes to zoning laws, we must give individualized notice. We must literally knock on your door and tell you we're about to affect your rights and what you can do with your land. That's true for zoning, but not all laws that affect land are zoning laws. For example, any of us familiar with Hannibal Square? Great place to shop, great place to hang out, great place to have a beer. Would you agree? But not a beer after 1 a.m. because there are noise ordinances. So you can't get a beer after 1 a.m. at Hannibal Square. You got to walk 2 blocks to Park Avenue and get your beer after 1 a.m. there, where the noise ordinance doesn't apply. A noise ordinance is an example of a law that affects land and what you can do on it that isn't a zoning law. Zoning is a law that has to do with the zoning map, which has to do with the master plan, which has to do with what can be done with individualized parcels based on where they reside on the zoning map. That's different than a noise ordinance. So just because you see a law that affects land and what can be done on it, don't automatically assume it's a zoning law. Don't automatically assume that you've got to have individualized notice. But if it is a zoning law, then you need that individualized notice. So now we add to the big board inconsistencies. Inconsistencies of law. And as you noticed, I had to break it down. So first I went to Roman numerals, then letters, then numbers, then I had to go back to letters, then I had to go back to like Roman numeral lowercase numbers, then there were numbers in parentheses. It's really getting into the nitty gritty here because there are different types of inconsistencies, different types of preemption that we want to cover. 2 types of inconsistencies we talked about were preemption and conflict. Conflict of laws and preemption of laws. Local ordinances are consistent. They are consistent with general or special law unless state preemption precludes a local government from exercising its authority, or unless state action expressly conflicts. How do I know when one law is in conflict with another? When is the legal standard of conflict met? When are there conflicting laws? Here is the answer. When obedience to one law results in a violation of the other law, then the laws conflict. Stated somewhat differently. If I break one of the laws by obeying the other, then those laws conflict. That's the kind of conflict that you might call an inconsistency. Another type of inconsistency is preemption, and we've alluded to this earlier in our lecture. Although state law may continue to prevail over conflicting county laws regardless of whether the county has a charter, charter county laws can prevail over conflicting municipal laws. They prevail whenever the charter county law is a regulatory ordinance, or they prevail whenever the supremacy clause says that they prevail. For non-charter counties, county laws do not prevail over conflicting municipal laws. Let's break it down. You got a county. Is it a charter or a non-charter county? How do I know? If it has a charter, it's a charter county. If it doesn't have a charter, it's a non-charter county. All right, so you don't have a charter. When do you preempt? Just about never. County laws do not prevail over conflicting municipal laws when the county is a non-charter. What if I have a charter? Then if it's a regulatory ordinance, the charter county prevails. The only other time the charter county is going to prevail is if the charter contains a supremacy clause, and the supremacy clause says that the county prevails over the municipality. So that's two different ways to say the same thing. But the ultimate question is, do you get it? Does it make sense? Any questions about when a charter wins? Let me ask the question then. You got a big county. I mean, there's hundreds of acres, okay? And you've got the newly incorporated city of whatchamacallit, 1 square mile. It's just 1 square mile within those hundreds and hundreds of acres. And city of whatchamacallit passes an ordinance that conflicts with the county. Remember, the county was huge. Who wins? Because the county's huge? Ah, you're covering your tracks. Yes, I was trying to deceive you. It wasn't the geographic size that made it win. Yes. Generally speaking, under my hypothetical there, I didn't mention whether the county was charter or non-charter, but that was the answer to the question. It wasn't a factor of size. I don't care how small the city is or how newly incorporated it is, it's going to prevail over a non-charter county. If that county turns itself into a charter county, then the city is not going to prevail over a regulatory ordinance, and it's not going to prevail over anything that the charter supremacy clause says the county prevails on. Everybody got it? It's a great test question because it's so easy to get it wrong, isn't it? Okay. So we've got two types of inconsistency. We've got preemption and we've got conflict of laws. When do two laws conflict? You can tell me. When is there a conflict of laws? What's the legal standard? It's on the big board. The test to determine whether there is such a conflict is whether one must violate one provision in order to comply with the other. In its most simplest form, if the Florida legislature says, thou shalt not do this, and then the city of Winter Park says, thou must do this, you've got a conflict of laws. Making sense? So these are the arrows in your quiver. I hope you've kept a list. Most importantly, I hope if we had examples of these laws and you were staring at the face of a law, you could tell me whether there was a violation of one of these. Because just imagine yourself, you're a lawyer by trade, you're proud of it. That's what you do for 60 hours a week or so. But 2 hours every week for 13 straight weeks, you pretend you're a law professor. And you give lectures at your local law school. And then you got to sit down, you got to write a final exam. It'd be awfully fun, wouldn't it? If you could come up with a series of hypothetical laws to see if or whether they were unconstitutional on their face, and if so, which of the arrows in the quiver have been violated? Because there's a lot of them up there, right? Some of them had exceptions. Some of them were a bit confusing. That'd be a cool thing to put on an exam, wouldn't it? Hint. Is this mic on? That's a hint. That's what I'm gonna do in the exam. Write this down, McGinley, on exam, will draft hypothetical laws and ask me if they're unconstitutional on their face based on one or some or none of these things on the big board right here, period. Therefore, if I didn't write these things down, I should probably get them off the website, flaconstitution.com, where I will upload them for the next 24 hours among the slides that you saw today, period. Anybody miss that? Okay, everybody got that. All right. Well, hey, this is valuable information. This is where the rubber meets the road. This is where you can take some of the theories of state constitutional law and actually put them to use for your client. I like to think of this class not only as something that was required, but something where I can empower you, where I can take constitutional law and make it your own, make it something you can put to use, make it more than you can just lament, oh boy, there's a constitutional law violation out there, where you can actually do something about that constitutional law violation to the benefit of your client, to the benefit of society. And that's why I like things like these arrows in the quiver. Thank you for attending this lecture. Next week, we will move to another branch of Florida government, the executive branch. And since I have less to say about that than I did the legislative, we may even, before that lecture is over, get to the judicial branch. And I hope to, because this is law school, the judicial branch probably deserves more than one lecture. So if I can start it next week, I certainly will, and that'll give it more than just one lecture. But, yes. Next week is spring break. Okay, then don't come next week. Come the week after that. All right, and enjoy your spring break. Enjoy your Lent. It starts tomorrow. Enjoy your studies. Thanks for putting up with me. May God bless each and every one of you. I'll pray for you if you care to pray for me. I'd appreciate it. Thank you.
Okay, so I gotta go to the, can you do me a favor, or just call my computer, things, PDF, or whatever, I'll let you know. Professor McGinley, I had a question on
Yes.
general lawmaking.